Welcome, everyone. Peace, peace, peace. Yusef here back with another live presentation. Today, I'm going to discuss what I focus on now, as opposed to, I'm gonna start trying to focus on what I actually want and not what I actually don't want. But what I really want is for everybody out there to really start to get a thorough understanding of public versus private and get rid of a lot of the echo chamber uh, ideologies that are being passed around that cannot be substantiated due to people having a very poor understanding of legalese and law and uh, you know principles of law in general. Private ordering, okay. This is what I discovered. I discovered private ordering. It's been around for centuries. It's not anything new. Um, it is a framework uh, that helps you to understand exactly how private rights are exercised. This is how private rights are exercised, especially in the modern world. It's been going on for quite some time. So I have put together a handout um, to kind of walk you through. This is an SBC University handout, and I put this handout together in order to help individuals kind of read along and follow along exactly what private ordering is, because it's something new and a lot of people haven't heard of it before. So I'm going to run through this quick because I ain't got a lot of time. So SPC University handout, the realities of private ordering, what it is, where it operates, and where it stops. Second edition foundational handout, read before any instrument is drafted. Okay, here's our central proposition. Private ordering is real, powerful, and extensively protected by law. It is also a permission the law grants. This is not something that you made up, or it's not operating outside the framework of the government or anything like that. It's operating within that. There's no such thing as operating outside the framework of the government in any country. Anybody telling you that, they really don't understand how the law operates. Private ordering is real, powerful, and extensively protected by law. It is also a permission the law grants, not an exemption from law, and not a space the law cannot reach. Every private instrument that works because a public rule says it works. You got to go to a public forum to get things enforced. You end up in their administrative courts. A contract binds because contract law makes it bind. A trust is respected because trust law recognizes it. An arbitration clause displaces a court because a statute directs the court to step aside. This is not a limitation on private ordering. It is the mechanism by which private ordering exists at all. A student who understands this will use the doctrine well. A student who believes private ordering operates outside or above law will misuse it, lose, and often pay penalties for the attempt. Who this handout is for. This handout addresses a specific and recurring error, the attempt to assert private rights inside a publicly regulated space, on the theory that the private character of the parties or the instrument removes the activity from regulation. And this is the biggest problem I see in the spaces. They think that simply by declaring a status, they are now exempt from any sort of public regulation inside public activity. This is probably the biggest thing that gets you labeled a sovereign citizen, and the people in the public just they don't really think that you're very intelligent at all. And I can understand why, because it is ludicrous, and it is an example of individuals who, when they read law, they don't understand that when you read words legal, like somebody today, they're telling me about an opinion. And they don't understand that the legal term opinion is different from the word opinion. And they say the Supreme Court gave an opinion, but they think the word opinion means the same thing in legal sense as it means in everyday parlance. And this is just a small example of the people. You can go over there right now in my last video and see people making comments like that. And they don't understand that these terms have a different meaning. Opinion doesn't mean opinion. The court is giving their opinion. That word doesn't mean the same, just like the word may. It has a legal sense and it has a secular sense. But the biggest mistake that you can make is coming inside of this space thinking that words that you use in everyday parlance have the same meaning that they use in the legal arena. And that is a mistake that a vast majority of these people make out there. Very simple mistake. And it's an example also, it indicates that they don't look up the definition of words. They won't look it up because if they just looked up the term, they would see that, but they don't look up the word before they speak. So the error is worth taking serious. Okay, say who this handout is for. This handout addresses a specific and recurring error, the attempt to assert private rights inside a public regulated space on the theory that the private character of the parties or the instrument removes the activity from regulation. That error is worth taking seriously rather than dismissing because the instinct underneath is sound. There genuinely is a broad domain in which persons govern their own affairs by their own terms, and the law protects it vigorously. The error is not in caring about private autonomy. The error is in looking for it in the wrong place, with the wrong instrument, and at the wrong time, and in mistaking a question of political philosophy for a question of positive law. This handout is written to give you the map, what the private domain actually is, how large it actually is, what instruments actually reach into it, and what will happen if you deploy them outside of it. Tag settled. Okay, and these the meaning as we go through this document. Settled means binding or holding a rule so uniformly applied it is not seriously contested. Contested, genuinely unresolved, split, or recently changed. Cite with the disagreement disclosed. Structural, a consequence of how the legal system is built, not of any single case, independent of which cases are decided. State law varies, determines by the law of a particular jurisdiction, verified locally before relying, and scholarship, not authority. A treatise, article, or empirical study may be excellent and may be wrong. It binds no one and settles nothing. Where scholars disagree, the disagreement is stated. All right, so let's go on. What private ordering actually is. This is part one. All right. Private ordering is the use of privately created instruments and privately administered institutions, contracts, trust, entity documents, association rules, arbitration, and other private dispute resolution to govern a relationship in place of the terms a public institution would otherwise apply. The scholarly literature is substantial and empirical, not speculative. Robert Ellickson documented Shasta County ranchers resolving cattle trespass disputes entirely by neighborhood norm, largely unaware of the actual law of trespass. Order Without Law, How Neighbors Settle Disputes, 1991. Lisa Bernstein documented the diamond trade operating for generations through internal arbitration and reputational sanction, with operating for with essentially no recourse to the courts. Opting out of the legal system, and it's the name of the book, Opting Out of the Legal System. You can get the book. These are all examples of people who currently use private ordering. These ranchers, they conduct all their business within their space, and they don't even know what the regular law is because everybody who's involved in the activity has made an agreement on how disputes are going to be resolved. So everything is contractual. This is how you stay out of the courts. The historical pattern and the myth built on it. Private ordering is ancient. Merchant custom, guild regulation, fair and staple courts, ecclesiastical jurisdiction, marine insurance, bills of exchange, letters of credit, and trade association rule books all long predate the modern regulatory state. Students are sometimes told that this proves private law once operated in a legal vacuum, and that is later subordinated to statute was a usurpation. The history does not support that reading, and the careful historical work cuts the other way. The law merchant was not what it is said to have been. The Romantic account, a universal, autonomous body of merchant law granted spontaneously by traders and enforced independently of political authority, has been substantially dismantled. Medieval merchant courts largely applied local law. Their authority came from town charters, fair franchises, and royal or seigneury grant. And the picture of a unified transnational lex mercatoria is in large part a 19th and 20th century construction read backward onto the sources. Emily Cadence, The Myth of the Customary Law Merchant, and The Medieval Law Merchant and the Tyranny of Construct. Here are all the sources. We're citing the sources of where all the information is coming from, and you can get those sources and read them for yourself as well. Scholarship, not authority. Read Cadence before reading anything else on this subject. The myth is in wide circulation and is the intellectual feedback of several failed legal theories. And that's what it is. What you have mostly going on in these spaces is intellectual feedback. It's just a failed legal theories that get circulated. I've seen some of these theories, how they started, and now they're still circulating today. Like birth certificate authentication and passport and all these different things that a lot of people are using to correct their status. I was there when all that started. I saw it started, and I've seen how it's changed. I see how it's no longer connected to its source anymore, and many of the people who use it, they don't even know where it started at. They're just doing it because somebody told them to do it. Even the strongest case for a stateless order is contested. The best-known scholarly claim that a trading network enforced contracts purely through reputation without recourse to legal institutions concerned the 11th century Maghribi traders. Anver Griff, the contract enforceability and economic institutions in early trade. I think that's Maghribi traders, Maghribi Traders Coalition. That's interesting. It's in 1993. That account was reappraised on the documentary record with the conclusion that these merchants did in fact make substantial use of formal legal enforcement. Jerry Edwards and Shengla Ogliglieve. I can't pronounce these names. I'm butchering these names. Forgive me. The debate is unresolved. Note that what is a debate about not whether a private ordering existed, but how much form legal enforcement stood behind it, even the limit case trends toward more law, not less. And let me say that, let me translate that for you. In antiquity, when people were using private ordering, everybody still had to resort to some sort of public type eventually, because contracts had to be enforced, and they had to be enforced, yet they have to go to the public. So if you can't get a private agreement, somebody to honor in a private agreement, you're going to have to resort to the public and then their administrative arm. And that's what you pay taxes for access to the statutes in case you need enforcement of something. Can y'all see this? Let me make sure y'all can see this okay. Make sure y'all can see this okay. I don't want to make sure y'all can see it all right. It looks like, can they see it? Oh, okay, yeah, you can see it. I see. Yeah, there it is right there, okay. The issue is that the AIs won't help explain things to the fullest extent necessary for enforcement. They're not supposed to. You're supposed to already know. That's because you're trying to use AI like it's Google. You don't know. You got to have some information to know how to use AI. You know, you're just asking, you're trying to use AI like Google. You don't understand what it's for. You think it's going to it's pulling from sources. And you got to know how to actually use AI. Everybody try to use AI like Google. They really don't know what they're doing. But anyway, let me keep going. Even the strongest case for a stateless order is contested. All right. So what actually holds the real historical variable? The question that discriminates is not, did a state exist? Something always preceded the modern administrative state. The question is, what made compliance rational? Historically and today, private ordering is sustained by one of two things: an authorization layer, a charter, a statute, a court recognition, enforceable judgment, or a closed community where repeat dealings, dense information flow, effective sanction, and high costs of exit. You know what? Let me tell you something. That's what, when I first got into this, a white man explained that to me. And he said, to read what people need to understand about this private stuff, he said, you have communities. He said, there are whole communities that do this, and they own their own land. And that makes perfect sense to me. Yeah, there's a private side, but you have to have your own community, and everybody in the community has to be in agreement. Like when you look at a homeowners association, that's one form of it. All right, but I'm talking about an actual private community of individuals where everybody has agreed, where if there is a dispute, nobody's going to go to the public. Nobody's going to go to the public. So you have to have your own insular environment to make that occur. And that's kind of like the closest thing that I have seen that comes close to that is the Amish of what they're doing. So Ellickson's ranchers and Bernstein's diamond dealers are the second kind. That is why their system works so well and why they do not generalize. Strip the community and the norms lose their sanction, at which point the arrangement is an ordinary contract enforced by an ordinary court. Even then, the two are not separate. Parties who never litigate still bargain against what a court would do if they did. Robert Munkin and Louis Koshner, that's what makes a private community work, because people understand, well, what would happen if we have to go to court? That's what prevents you from going to court. We don't want to go to court. If we have to take this to court, this is why this works inside of the framework of the public, okay? This is how private rights operate. You know, you have to be in agreement. Contracts is what we operate through on the private side, contracts. On the public side, what governs is the Constitution. I've said this for the last 20 years. I got a better understanding of it now, but contracts is what rule on the private side. So you got to have a community of individuals where all of you agree to operate through these contracts and you agree what the rules will be. So in other words, you're creating your own society. You have the permission to do that. You have the permission to do that, and you have to have that in writing. David Koresh in the Waco incident, he probably, and also Dr. Malachi Z. York, a lot of them probably would have been successful at what they were doing if they had understood this right here. You know, their organizations would probably still be operational. If they understood, well, look, you got to get a contractual agreement from all the members that if there is any, there have to be a rules of the community, okay? Rules of the community. How is the community going to govern itself? And what happens to individuals when they violate those rules of the community? But at the back of that, there's always the specter of, if we have to take this to court, this will happen. That's what keeps the private community private, because they don't want to go to the public to get any type of resolution on anything. I'm teaching you how private actually works. This is something you can all verify. This has hundreds. It ain't none of this echo chamber stuff. They don't have anything to substantiate what they're saying. All this, what I'm talking about, we can go and read in history how this is conducted, how privacy is actually conducted. Today, you see examples like in private member associations, like the Masons, the Illuminati, the Skull and Bones. All of those are private member associations. They have an internal governance that they operate by. And if you violate, there's consequences that they are the ones that exact out, that you've agreed to. And the best example of that is John Wick. If you watch the movie John Wick, that's a private member association. That's a very excellent example of a private member association. They were using gold to conduct their affairs with. They weren't using any Federal Reserve. Matter of fact, they would burn Federal Reserve notes. They didn't have any use for it whatsoever. They got paid for something, they got paid in gold. They kept everything private. You're trying to assert that in the public. You can't do that. So let's go on. It says, the historical lesson is therefore the opposite of the one usually drawn from it. Private ordering is very old, and so is the authorization layer. The pattern in subsection 1.3 is not a modern imposition of an older freedom. It is how things have always worked. This is how privacy has always worked. Tons and tons, I found tons and tons of documentary evidence to support it. This is the door you're looking for that you're going to walk through. All right? If you want to do this the right way, if you want to get away from all this hunting and everything for a Treasury Direct account, you're trying to figure out, how to operate a motor vehicle and without tags and all that kind of stuff right there. That's not how this is done. It's done by you putting together your own community of individuals, and then you forming an agreement, and it's reputation controlled, reputation based. So the reputation of the community is what controls. And like it said, it's too expensive for you to leave. Like, for instance, in a trust situation, a lot of people, they keep their families together through the utilization of trust. I think Warren Buffett, I think there's a video on the internet called like the 1% or the 2%. He cast his daughter out of the family and access to the family trust because she broke one of the rules and spoke to the media. They have rules that no one in the family can speak to the media. Well, she elected to do that. Now she's living like an average person. She a woman, probably got programmed by feminism or something like that. Don't like no man telling her what to do. And now she's living an average lifestyle, had to go get a job, living, and everybody sees that. Nobody wants, they made an example out of her. And the rest of the family, they living the life of lives. You know, they born into wealth and they're living through wealth. All right? Who wants to mess that up? That's how you keep your family together. You make a trust indenture agreement. The money is what keeps the family together. And you make it very expensive to exit the family. And you draw that up in the indenture agreement. It's not saying they can't leave. They can leave, but it's going to be very expensive for them to do so. And that's called a reputation-based system. And that is what private communities operate through. Okay? So let's keep going. Private ordering is a delegation, not an exemption. This is the proposition on which everything else in this handout depends. The delegation principle. Ask of any private instrument, what makes this enforceable? How are you going to enforce it? A contract is enforceable because the law of contract supplies a remedy for its breach. A trust is respected because trust law recognizes the separation of legal and equitable title. A corporation limits liability because the statute says it does. As arbitration award is binding because the Federal Arbitration Act, Title IX, United States Code, subsection 2, makes the agreement enforceable, and subsection 9 through 11 direct courts to confirm the award on narrow terms. In every case, the answer is the same. A public rule confers the effect. Remove the public rule, and the private instrument becomes a piece of paper describing an intention. It follows that private ordering operates inside the legal system. In the space the system leaves open, it cannot operate against the system because it has no force independent of it. You know, I kind of liken this like in the occult circles, we state there's only one power, okay? There is no power outside of God. Because no one can force God to do anything. So God is the same today, yesterday, and every day. God is not subject to change. All right? Change cannot be forced on God, because that would mean there would have to be some power outside of God to force change on God. So it stands to reason that God is changeless. He's the same yesterday, today, and tomorrow. You hear Christians say that. That's actually an esoteric principle. It doesn't originate within Christianity. Just like meat is for babes and milk is for babes and meat is for men, that's not a Christian term. That started in the esoteric circles as well. This is what I'm talking about when you study the principles of something. You can trace it back to its source when you understand the principles. Study the principles and you can trace it to its source. All right, so it goes on. Okay, in every case, the answer is the same. A public rule confers the effect. Remove the public rule and the private instrument becomes a piece of paper describing an intention. It follows that private ordering operates inside the legal system. In a space the system leaves open. It cannot operate against the system because it has no force independent of it. You don't have anything to enforce your private agreements. You're running up in the court trying to tell these people that they don't have jurisdiction over you, and you don't have anything to enforce what you're saying. Structural. The point is made most cleanly by arbitration, the strongest form of private ordering in American law. Parties may choose their decision maker, their procedure, their governing rules, and their remedies. What they must not do is to expand the grounds on which a court will review the result. The parties cannot contract for a broader judicial review than the statute provides. Settle. You may privately order the dispute. You may not privately order the terms on which the public system engages with your private order. All right, you don't make the rules for the public. If you have to come to the public, you got to follow their rules. You don't make the rules. Public and private do not mix. 1.4, the three kinds of rules. Every legal regime is built from rules of three types. The entire question of what private ordering can accomplish reduces to identifying which type governs the matter at hand. Type of rule, a default rules, supply a term the parties did not address. Displace them freely. What private ordering can do with it. Displace them freely. This is the home territory of private ordering, and it is enormous. Most of contract law, most of the law governing entities, most of trust administration, and most of commercial law consist of defaults. Default is the biggest thing. You put your default provisions in your contract. Altering rules, specify how a default may be displaced. Writing, signature, conspicuousness, magic words, filing. Okay, what private ordering can do with it. Comply with them exactly. A displacement attempted in the wrong form fails, and the default snaps back. Most drafting failures are altering rule failures, not substantive ones. Mandatory rules apply regardless of party agreement. What can private ordering, can it do with it? Nothing. These cannot be waived, disclaimed, contracted around, restructured around, or opted out of by any instrument, however drafted, and regardless of the sophistication or consent of the parties. A lot of you think that, oh, well, they only have a jurisdiction over me if I give my consent. That's not how the public operates. See, the problem with you, you don't know how to exercise your private rights. That's what I'm trying to show you now. You know, you got to understand that privacy is exercised within a certain framework and within a certain space, okay? And I'm showing you what that space is now for you to operate in and how you actually conduct your affairs within that space, if privacy is what you're truly after. All right, but a lot of you are mad with the public and the government, and you don't like the way they run things in the public. And if you want to change that, that is done by the ballot box, okay? Because we are their constituents, and we decide who we send up on Capitol Hill, but that's a public matter. It's not a private matter. The Constitution is there to keep them out of the private, and I'm showing you what the private is. That's why one of the articles of the Constitution or amendments of they can make no law that will infringe on the obligation of contracts. They can't make that. That's our superpower. But contracts can work for you or against you. You can sign a contract with the devil. Contracts work for you or against you. The framework is developed in Ian Ayres versus Robert Jertner, Filling Gaps in Incomplete Contracts, an Economic Theory on Default Rules. Here's the book you want to get. All right? Like I said, this document is replete with sources. We cite the sources. Where did I get the information from, and where can I learn more about this? This is just a student handout. You know, I do these all the time on SBC University. When did I do a video on State versus Stephen Durante? I don't know what you're talking about. Well, I mean, what's the name of the video? I probably did. That's probably not the name of the video. The distinction appears in the statutory text itself. You do not have to infer the line. Contract law is not Black's Law Dictionary. I don't understand why you would say that. Contract law is some of the oldest law that's been around before Black's Law Dictionary ever was in existence. Contract law existed. All right, okay, so I'm gonna have to block you because you want to have a conversation and you don't seem to understand that when you come on my live, you don't start talking about things outside what I'm talking about. I'm not here to talk about Patrick Devine. I'm not here to talk about none of that shit that you're talking about, all right? I'm here to talk about that. All right, you want to talk about something? Hey, I'll be in Nevis next month. I'll be there. I'll be there next month. So please don't come on my channel having conversations about things because that's disrespectful, because what you're saying is you're not interested in what I'm talking about. None of those people that you named, they don't know anything. They're not an authority on anything and have no interest in any of it, okay? I'm not here to talk about a case I've already talked about before. I'm here to talk about private ordering because that's what these people want to hear about, because you don't even understand that what you're talking about because you don't understand this right here. If you understood this, you would understand all of that. So please don't do that in the future. And hopefully I've made an example out of him, and anybody else does that, that's something that's a pet peeve of mine. All right, that's like really, really disrespectful. Like when people come in and they start talking about, you know, other stuff other than what I'm talking about right here. If you're not interested in what we're talking about, go to another channel. You're free to go to another channel because I'm not going to be tolerating that. This is important information. I know a lot of you, y'all don't have the student mindset, or maybe this might be too transcendent for your capacity to comprehend, and or you may not be desirous to understand it, like most of you don't, because you already think that you know, and you don't know because you get all your information from echo chambers. I'm here to combat that, and that's what I'm doing with this information right here. So right here, the reserve police power is a term of every contract. The reserve police power of the state. Parties contract against the background of existing law, and the sovereign's essential powers are treated as incorporated into every agreement. The Supreme Court has long held that the reservation of essential attributes of sovereign power is read into contracts as fully as though expressly written into them. Home Building versus Loan Association, there go the case law citation right there. That's a very powerful citation of authority. That's the kind of citation of authority you need to be circulating around into the echo chambers. You probably won't, because that's going to open the door for making people to understand private ordering. And you don't want them to understand private ordering, even though this is how private rights have been exercised for centuries, because you want to keep going with that stupidity that is going on in the echo chambers. It's time for all that to stop. All right, we're in a different age now. Time for that to stop. We're in the age of enlightenment. This is a renaissance within the sovereign community. This is not a doctrine of hostility to contract. It is a doctrine about what contracting parties are understood to have agreed to. No instrument can be drafted so as to exclude it because it is a term of the instrument. Whether it's expressly written into the contract or not, there's always the background of the courts, because that's where ultimate enforcement is going to have to come from. Even if it is a private contract, where's your enforcement? Now, true private ordering is you got your own enforcement too. That's why I was talking about like John Wick. They got their own enforcement. They've agreed to their own enforcement. They've agreed to their own everything, how they do their business and everything. They don't go to the public for anything, for anything. So part two, the distinction being missed. Private names three different things. Almost every failed private ordering argument rests on collapsing these three. Sense of private, private party, what it actually means. The actor is not a government actor. This affects which body of law applies. Constitutional limits generally bind government, not private persons. Boutwell versus McDowell, volume 256, U.S. Reporter, page 465 and 475, published in 1921. It says nothing about whether the activity is regulated. Private relation. The relationship is created and governed by instrument between the parties. This affects what the parties owe each other. It says nothing about what either owes the public. Private default rule. The governing rule is one that the parties may displace. This and only this is the sense in which private ordering has power. Now, private, a lot of people, they think I'm operating in the private. Listen, there's a public and a private. You got to know when you're in each one. They don't mix. I ain't never said you have to be totally private. You can't mix them. One of the rules is you can't mix public and private. So if you're in the public, you got to follow the public rules. When you're in the private, you've made your own rules through contract or whatever. There's a public and a private, and they don't mix. Okay? You can't say I'm private and then leave the private domain and come into the public and start trying to assert some sort of private right or private interest in something. No, you are in the public now. That's the only thing I'm trying to get you to understand. Okay, I'm trying to get them, you got to understand this is where the sovereign community is wrong. They take that term sovereignty to mean all powerful, as if because we delegated powers to our government officials in some kind of way, we are superior to them in every aspect. And this is why I encourage people to study trust law, because if you study trust law, then you would understand how that works. Like when a settler actually conveys property to a trustee through some agreement called an indenture agreement, if it's an irrevocable trust, the trustee is all powerful now. The settler don't have any power outside of the instructions that he gave to the trustee, which the trustee has what is called a punctilious of an honor, the most sensitive to follow by, okay, which are also your government officials likewise have that same level of fiduciary duty. So when you understand trust law, then you would begin to understand your relationship with the government, and you would stop trying to assert private rights within the public space. What we did was we have a limited government, and the bounds of the Constitution is to keep them out of the private domain. However, and there are certain amendments in the Constitution that do that. One of them is you cannot take private property without due process of law and just compensation. You cannot make any law that will affect the obligation of contracts, just to name a few. I think there are like 4 or 5 of them in there. But those are what keep them out of the private. Now, you have to know how to utilize those particular amendments in the Constitution to operate within your domain. Okay, it's just not something that you just get arbitrarily and capriciously or by default. You got to actually know how to use it. It's not nothing you just walk around with just because you declared something on a piece of paper. That is foolish, and law does not operate that. Everything in law operates in what is called substance over form. And you would do well to understand that equitable principle, because it is utilized all throughout the law. Substance over form. Your actions speak louder than your words. Criminal intent. That can, and let me tell you something, and they will construe that through your conduct, what your intentions were. Listen, your understanding of the law and what privacy is very poor. It's very, very poor of what you're being told. This is next level right here. This is what we teach at SBC University. All right, we're coming from the actual case law. This weekend, I'm going to be having a webinar. I'm going to be going through a lot of the old information, okay? Because I know people are interested in how to do an administrative process, how to, your UCC1 filings. Why are you filing the UCC1? How do you construct a negotiable instrument, a bill of exchange? How do you actually make a presentment of a negotiable instrument in an attempt to set off an obligation? All of these things I'm going to be discussing, GSA bonds, all these things. I'm making a brain dump because it's probably going to be the last webinar that I conduct on those particular topics. So if you're really interested in that information, I would advise you to be in that webinar. It's going to be well worth it. It is a 2-day webinar. It is on the 29th, I believe, from this Saturday from 11 a.m. to 3 p.m. and on Sunday from 1 p.m. to 4 p.m. So you may want to, sign up for that. Spaces are limited. It's going to be good. Dude was talking about Patrick Devine, like Patrick Devine was like, don't nobody even understand. I don't even understand what Patrick Devine was talking about. I got all this stuff. I don't even understand what he was. I read that stuff. I don't even understand what he's trying. He's like some mad scientist trying to put something together and based off of a limited understanding of things like trust law and things like that. He's trying to, what Patrick Devine was attempting to do was collapse a trust, because he was saying that the government has a trust. And so you attempted to collapse it. You collapse a trust when equitable and legal title come together, and that usually is through the doctrine of merger when you have the settler and the beneficiary being the exact same person. He didn't really understand that thoroughly, but he was trying to use that in order to collapse a trust and then make a new trust, the beneficiary of that trust, because when a trust collapses, everything in the trust has to be transferred to the new trust. So he's trying to create this new trust that he has control over, this grantor trust. And it was just based off of very, very limited understanding of trust law. You know, you want me to talk about it, but I can talk about that because it's related to this right here. But it's like, you know, I know that's your hero and everything, but I'm on a totally different level. You know, I look at those guys' things and it's like, these ain't no authorities on anything. I hate to say that to you. None of y'all can even talk about what he was talking about, like what I just explained right now. Because when you look at those documents, you won't even understand what he's talking about. He's using a lot of archaic language. You know, he went back and tried to use a lot of language that come from the Admiralty that you would only really understand if you had taken time to study something like the Clerk's Praxis or Benedict on Admiralty or something like that, which I've done. All right, you're not going to be able to, you know, so when you look at it, you can see that he has a rudimentary understanding of the information of what he was attempting to do. I mean, people liked him, you know, y'all liked him, but maybe because his personality saying, well, you know, because I know he used to always say, you know, if you're going to charge people for information, then you go and get this money and shit like that. But, you know, I'm not teaching there's some secret bank account that you can go get money out of and things like that. That has never been anything that I've taught because I understand the purpose of a bond and how private banking works. It's not you going and getting anything from the public. It's something that public and private don't mix. And there is no money. You are the value. That's the thing that we're taught in Secure Party. The value is derived from you because you are capable of performing labor. That's why they use an actuary table and determine your value through your lifetime. And that's how they go and borrow money because you have to have some sort of value in order for them to borrow money off the good faith and full faith and credit of the United States. And the guarantors of the repayment of that are the United States citizens. Because you have to have some sort of value. That's why they have that's why they have a minimum, what is that? Minimum wage. You don't notice they don't have a maximum wage because nobody can determine what human being will ultimately accomplish and what will be their value. You could be the next trillionaire. Nobody's able to calculate that, but we can determine what your minimum value is. And that's what they use to calculate, and they go and borrow money against your lifetime minimum value. If you work minimum wage all the way the rest of your life, they got an actuary table where they can determine that. You have to have some sort of value, okay? So a person that operates within what is called a welfare state needs the government to do everything for them. This is why you were sending notices to the government stating that I am more than competent enough to handle my own commercial affairs because this operational presumption, which y'all like to characterize as a minor account, because you got this definition of minor, you're associating it with incompetency when it really is talking about an age limit, but you want to associate it with incompetency, which there is some precedence for that, but that's not what we're talking about in this particular. All right? You're looked at as incompetent because you needed to come to them for help. And so if you went to the government, then you need help of the welfare state. Doesn't matter how old you are. You're not competent enough to handle your own commercial affairs. So you need to demonstrate competency by understanding how to operate it. You're supposed to know how to conduct private business. If you're a private businessman, you're supposed to know how to put together a bill of exchange, a promissory note. You're supposed to know how to do all of that. If you're talking about that you're some sort of private type of entity, you're supposed to know how to draw up a contract. These are things that private people know how to do if you're going to operate in the private, as you like to say. Privacy is an ecosphere. It's not just something you declare and then you walk around thinking you have it. That's not how it works. What time is it? Okay, I got to make this. I keep going. I'm in 43 minutes. Because they regulate the welfare state in their private contracts. What do you mean? I mean, it's public. You're right. You know, you come into the public, you are making slavery moral and legal. It's not slavery. You are voluntary. Slavery is not, first of all, only involuntary servitude is not permitted under the Constitution. It don't say nothing about voluntary servitude. You voluntarily went into servitude. Nobody told y'all to give away y'all land. The United States of America was an agricultural country up until the early 1900s, before cities started to become a major thing. Okay, you left the countryside where you had your own land into the city for convenience, to get a job, to have access to movie theaters, to convenience stores, to drive automobiles and all of these different things. When you live in a city, you're living in a convenience store. Everything is convenient for you. And that's what you are paying for. That's what you're taxed about. And that's why you're being subjected to statutory regulation, because that's an ecosphere of benefits and privileges. And benefits and privileges are always subject to statutes because they're derived from government. I don't even, you know, an omnibus, you don't know what an omnibus? Y'all trip. Y'all just go find a word and think, you know, omni means all. Okay, so I'm gonna let you just let you wonder, do I know what it is? But that's how they capitalize on our ignorance. Okay, well, ignorant, those who chose to be both ignorant and free are hoping for something that never has been and never will be. Being ignorant is something that's willful ignorance. That's on you. Ain't nobody's fault you ignorant but you. Ignorance of the law is no excuse. Ignorance of anything is no excuse. It's on you. If you choose to engage in some sort of activity and you haven't taken the time to understand it, okay, you're operating in ignorance, and everything has a cause and effect associated with it. So that's on you. That's not on them, because you're operating in ignorance. See, to be a sovereign, you got to take accountability. And that victim shit is not going to fare well in a private space. Ain't no victims. You got to be responsible for you. All right, you try to blame them. They taking advantage of us. They doing it. Yeah, they're going to take advantage of your ignorance if you let them. United States of America is an adversarial system. There's nothing in it that promises that they're going to do something for your benefit. Nothing about it. They do everything for the benefit of the public. And they say that in all their documentation. You just haven't understood that you're not the public. They say we preserve and protect the public. That ain't you. That's the government. The core error argument runs, the parties are private, therefore the relation is private, therefore the rule is private, therefore we may set our own terms. That's what everybody in the echo chambers think. Each step is a non sequitur. Two private parties in a private relation are constantly governed by mandatory rules. An employer and employee are both private. So are a landlord and tenant, a broker and a customer, a doctor and a patient, a lender and a borrower. Every one of those relationships is heavily regulated, and the regulation applies precisely because of what the parties are doing, not despite the fact that they are private. 2.2, the test is not who the parties are. The operative question is never, is this private? It is the governing rule mandatory or default. Those are different questions with different answers, and the first does not predict the second. Congress has in several places voided contractual waiver expressly, which removes any argument about Securities Act, Exchange Act, Fair Labor Standards Act. Rights cannot be waived or settled by private agreement because the statute serves as a public purpose beyond the individual employee. All right? More generally, a promise is unenforceable on grounds of public policy where legislation so provides, or where the interest in enforcement is clearly outweighed by public policy against it. Okay? You can't make a contract that goes against public policy. That should be, everybody should have understood that by now. All right? Because they're not going to enforce something that goes against their own rules. So whenever you write a private agreement, you always have to contemplate the public. Don't ever, that's even in trust law. You cannot write an indenture agreement that's going to violate something publicly, because a trust is a creature of equity. And the equity courts have the authority over all trust, regardless of whether you think so or not. People talking about, I've got an arbitration agreement, so I have to go into court. Yeah. However, that does not eliminate the jurisdiction of the court over that, because there's always the specter of some necessity that you may have to eventually go into a court. So it's always going to be there, floating in the background. You just conduct your affairs in such a way, and hopefully you'll never have to go that route. That's all privacy is when you're acting in it. It's just, hey, reputational based systems, okay, the relationships is what govern, and we're going to honor those relationships so we never have to end up in a public forum to settle some sort of dispute. Because the court is where disputes are settled. There are places where disputes are settled. There's some sort of dispute. So if you don't want to have the public settle your dispute, then you make up the rules to handle it privately. And if you want to operate in a community, you can have a whole community like that, where the entire community is under contract. And these are the rules for the community. Private member association. That's what YouTube is. YouTube is a private member association. They have terms of use. We have to follow. You have what is called freedom of speech, but you can't exercise on YouTube because you're under an agreement. They can make no law that will infringe on the obligation of contracts. You're under an agreement. You don't have no right to say whatever you want on YouTube. You can contract those rights away. And they're going to honor the contract. So the nuance that matters, form is not right. Private ordering can change where and how a statutory claim is heard, even when it cannot waive the claim. A party who agrees to arbitrate a statutory claim does not forego the substantive rights the statute affords. It submits to their resolution in a different form. Mitsubishi Motors Corp versus Solar Chrysler Plymouth. They're the citations. I ain't gonna read all those citations. Those cases, you can pull the cases. Settled. Learn this distinction precisely. Procedure is broadly orderable. Substance often is not. It explains most of what private ordering can and cannot achieve. What changes when you enter a regulated space? When you come into the public, what changes? A regulated space Sorry about that. Okay. What changes when you enter a regulated space? A regulated space is an activity the legislature has conditioned. Entry is voluntary. The terms are not. Once inside, the regulation defines the activity. It is not an external burden laid on an otherwise unregulated private right. Okay, in other words, when you come into the public, you're subject to their rules. You can't exercise privacy in a public regulated space. Problem with a lot of you is you don't seem to understand what constitutes a public regulated space and what does not. The recurring student error is to treat entry into a regulated activity as though it were an ordinary private transaction with an unwelcome overlay, and then to draft an instrument declaiming the overlay. The overlay is the floor of the room. It cannot be disclaimed from inside. You thinking that you can declare yourself out of their jurisdiction, essentially. I'm trying to put it in terms that you understand. That you think that you could declare yourself out of their jurisdiction by a written piece of paper. That, you're going to still keep engaging in the very same conduct, but now since you've given a notice to a public official, something has substantially changed, and now you become immune from any type of process or from having to follow any of the rules and regulations in the public. You are a terrorist, and I have to agree that you are a terrorist. You are a terrorist, and they're going to show you. It's not even a word. A lot of people, when you do that activity, you don't really understand the government in the United States. See, God sent me. That's why He sent me through all that first, before I came out here and talked to you. See, people who talk to you who've never been through that, okay, they don't understand. Okay, the government don't fuck around. All right, when they sick of your shit, they coming for you. When they coming for you, they coming to shut you down completely, 100%. And y'all are closely starting to go into that area where they're getting ready to come and shut you down. All that right to travel shit, that's all that right there is just going to lead to some serious government action to be taking place. That's what's going to happen. And so that's what people want to happen. They want some sort of, civil war to jump off or something like that, based off of some ignorance, some type of right that they think that they have, but they haven't really taken the time to seriously investigate. So they think that morally or in some kind of way that they have some moral high ground when there's nothing that they have demonstrated in their own life that could, give credence to that assumption. So let's keep going. What changes when you enter a regulated space? A regulated space is an activity the legislature has conditioned. Entry is voluntary. The terms are not. Once inside, the regulation defines the activity. It is not an external burden laid on an otherwise unregulated private right. In other words, public and private don't mix. That's the rule you have to say. They don't ever mix them. Don't you mix them either. I've said that a million times. They're not mixing public and private. They don't do that. When you go and read administrative law right there in the second section, it talks about that their concern is the public interest. They don't have no interest in protecting private rights in any way. They have no interest in that. If you need to get defense for private rights, you need to go to a constitutional court. But you need to make sure that it's a private right that you're defending. Because if you are in an administrative court, it is something that is concerning something wholly public, something that happened within a regulated space. They didn't come into the private. You left the private and came into the public. And now you're expecting some sort of protection of your private rights, and that's not going to happen. You got to be in the private space, and then if they come into the private space, that's when you come to the Supreme Court and say, look, hey, I was in my private space, and they came in without my authorization, without my invite. That's what they there to protect. Not you as a private individual leaving the private and coming into the public and thinking you can do whatever you want to do. That's not how it works. You got to understand what public and private is. And a lot of you don't understand that. These are domains. They're not statuses. They are domains. Stop trying to ascribe privacy with a status. Privacy is a domain. It's a domain you function in. And when you leave that domain, you leave the protections of it. And when you come into another domain, the superior man stays in his own domain. The superior man stays in his own domain. You're only superior in your own domain. You're not superior in their domain. Equity is a body of principles. We teach it every week at SBC University. That's all we go over is the equitable principles, and we know how they're applied. Like what I said earlier, substance over form is an equitable principle that underlies all the law. Equity is in the background of all the law, and substance over form is behind everything. Okay, so it is actions speak louder than words. You can't declare yourself out of something. Some people don't get it, and that's why we have to have a civics class, because this is basic civics. This should be taught. This right here should be taught in elementary school. This should be taught in elementary school. This should be in I'll say about 4th, 5th, and 6th grade. Students should be introduced to public and private, so they can start getting the concept of what that is and what their private rights are. But they aren't taught that because public education is only there to teach individuals how to be good employees for the public machinery. It's not there to vindicate private rights in any capacity whatsoever, which is exactly what they say in the administrative law handbook. When you get in American jurisprudence and you study administrative law, they're going to tell you almost what I just said word for word. That's not what they're there for. Their only concern is the public and for you to have compliance with the public policy. And the public is a space where benefits and privileges are largely exercised. Okay, that's what you got to understand. You got to start looking at it that way. I'm telling you, it's a lot of dangerous things that are starting to jump off because of the information that's coming out of these circles. It's leaking into other areas of society, and people think that they can just talk to the police any kind of way that they want and do things like that. Now you put in things in a danger. I just seen a girl shoot somebody the other day. You know, this police officer, she actually just really believed that the police didn't have no right to pull her over, ask her for a driver's license or anything like that. And she pulled out a gun and shot the motherfucker. Excuse me. I mean, like, damn. You know what I'm saying? You don't see that happening, and some of y'all thinking she's justified in doing that, and she's not. She's involved in a public regulated activity, operating a motor vehicle, no matter how you want to style it, because it's not about status. That activity is governed under the police powers of the state because it's a public safety concern, okay? And you don't understand that. And all the case law, I got some guy, I can't believe they're on my other video telling me if I read this case. I've already reviewed every single right to travel case says the same thing. Every last one of them. Every last one. All right? Every last one of them. I can review all of them if you want me to. And they all going to say the same thing, that a right can be regulated. A right can be regulated. If it poses a hazard to the public is going to defend itself from it by making regulations. You do got a right to travel. That only means to go from state to state. It says nothing about the mode of travel. The mode of travel, if it poses a threat to public safety, can be regulated. That's been consistent in law for at least the last 100 years. At least the last 100 years. All right, let's get back to private ordering, because you don't even understand Trading with the Enemy Act. If you go to my SBC group, I already did an entire handout on the Trading with the Enemy Act, so I'm not going to rehash it right here. You can go over there and read it. What changes when you enter a regulated space? A regulated space is an activity the legislature has conditioned. Entry is voluntary. The terms are not. Once inside, the regulation defines the activity. It is not an external burden laid on an otherwise unregulated private right. The recurring student error is to treat entry into a regulated activity as though it were an ordinary private transaction with an unwelcome overlay, and then to draft an instrument disclaiming the overlay. The overlay is the floor of the room. It cannot be disclaimed from the inside. Regulated activity, operating a motor vehicle on public roads. What the regulation actually conditions. A state may require registration and licensing and may condition its use on highways. Hendrick versus Maryland. Okay, volume 235, U.S. Reporter, page 610 and 622, 1915. Reitz versus Mealy. Volume 314, U.S. Reporter, 33 and 36. Settled. Note carefully, there is a constitutionally protected right of interstate travel. Saez versus Roe. And it is not a right to operate a motor vehicle unlicensed. Conflating the two is the single most common error in this era, and that's what I just hashed out to you. The problem how they tricking everybody is they'll say, you have a right to travel. Well, that's true. You do have a right to travel. But right to travel don't mean operate a motor vehicle. Right to travel, it means you have a right to egress state to state unmolested. Okay, because these Europeans who came from England, they mapped out America just like England, like Greece, Italy, Greece, Spain, France, Portugal, New Zealand, Germany, all those countries, Belgium, all those countries over there, where they look like a map of the United States. Here we have Texas, Louisiana, Georgia, Florida, Tennessee, North Carolina, South Carolina. These are countries here, but over there they require a passport. Over here, we say, no, we're going to give our people the right to travel. So what that means is you can go across borders without having to present any type of identification, which means you need some sort of permission. It's not talking about the mode of travel. The mode of travel gets into public safety. Now when you're dealing with something such as a 6,000-pound piece of metal, okay, that is capable of injuring someone, now that falls under the police powers of the state. You don't want to study that, though. I understand that that's hard. It's hard for you to understand that. But it's one you don't read case law because the cases that Thompson versus whatever is saying the same thing, exact same thing. He said, "Give me the holding on that in one sentence." Thompson's license was taken from him without due process. It didn't say anything about they could not regulate the activity. As a matter of fact, it confirms that they do. You can tell these people they don't read these cases. They don't really read them. Okay, offering or selling securities, registration or documentary exemption with its own conditions and filings. Structuring a transaction privately does not exit the act. It selects a different compliance path within it. Employing labor, wage, hours, safety, and withholding obligations that the parties cannot bargain away. Practicing a licensed profession, licensure conditions attached to the practice. Styling the relationship as a membership, ministry, or private association does not alter what is being practiced. State law varies. Verify the definition of practice in your state. It is usually broad and conduct-based. Serving food, lodging, or the public generally. Health, safety, and public accommodations regulation attaches to the conduct. A membership label does not convert a public-facing operation into a private one for regulatory purposes. Notice they're using the word public-facing. It's dealing directly with the public. You can't privatize something like that. No matter, you can't contract it away or nothing. The private law reads, and the state is not bound. There's a way to see this using nothing but private law, and it is worth stating because it is the it is the argument students find hardest to dismiss. The private law reason the state is not bound. Privity. An instrument binds its parties. It has no effect on anyone who is not a party. This is elementary contract law and no one disputes it. The state is not a party to your contract, your trust, your operating agreement, or your association bylaws. It did not sign, did not assent, and gave no consideration. Therefore, your instrument has exactly the effect on the state that a contract between two strangers has on you. None. Not because the state is powerful and not because courts are hostile, but because you cannot bind a non-party, and that rule protects you far more often than it constrains you. I don't think people think about that. Yeah, the state is not a party to your contract, and that's why nothing is binding on them. That's interesting. That's another reason why in the secured party process, you attempt to make a contract with the government. That's why it's a private affair. You know, when you really understand the secured party process, you understand the private aspect of it. And then you'll see why the people who try to denounce it, they don't really understand it. It's like it's a private agreement. You're entering into a private agreement. Everything is to be done privately, okay, without any type of public intervention. And that's why a lot of it doesn't work, because it ends up in the public. And it's not supposed to. That's the truth of it. Public and private don't mix. They don't ever mix them. Don't you ever mix them either. Okay, structural. The same principle explains why a trust cannot defeat a creditor whose rights vested before the transfer. Okay, that right there, people should understand. You got what's called a fraudulent transfer. All 50 states have a uniform fraudulent transfer act. Okay, if you try to transfer property into a trust and there's some sort of civil process already underway, that's going to be interpreted as fraud, and they're going to unwind that. Okay, and this is what I tell people, that you can't put a house in a trust and think it's going to protect it from a foreclosure. That is fraud. Now, if you did it 18 months out and there wasn't any lien against it, that's a different matter. That's a different matter. But an encumbered property, nah, that doesn't work. Yeah, it definitely will help with the information Mr. Brewer is teaching. That's why I was able to understand a lot of things when we met he was talking about. Securitization, yes, most definitely. Most definitely will help you with that. Yes. Because you're really being taught how to securitize something. That's what a secure party process is. It's securitization. You're learning how to securitize assets and make a private agreement. So to reach a non-party, you must use a public register. Section 2.4 states the limit negatively. Here is the same principle stated affirmatively, and it is the answer to what students in this area actually want. There is a way for a private instrument to bind the world. It runs through a public act. The law does not leave you with only the parties. It gives you a register, and the price of admission is disclosure. Secure transactions. A security interest attaches becomes effective against the debtor by agreement, value, and rights in the collateral. UCC subsection 9203. That is pure private ordering, and it binds the two parties completely. That's why I'm telling you, this is private banking. You learn how to securitize and bring value to assets, and then utilize an instrument representing those assets in commerce. That's what you're doing. So yeah, it's going to teach you the exact same thing. It's going to teach you exactly, because that's what he's doing. That's what all of them are doing. They are looking for you have to have some sort of value that's usually going to be attached to some sort of asset. And the more immovable, the better, right? Because movable property like gold mines and diamond mines and, immovable property, that's optimal because can't nobody move it. It can't be stolen. It can't be moved. And then whatever whatever it contains also can increase its value. So that can be securitized, or like a lady the other day, she was talking about her album that she has royalty rights, and she receives those, and she could securitize that. She definitely could securitize that. She could, because there's value there, and there's a stream of income. If you had a whole bunch of properties, say like you had 600 properties, and you were getting rent on all of them, you can securitize that. Or if you had a whole bunch of apartment complexes, what do you think they're doing on Wall Street? That's all they're doing on Wall Street is just securitizing. They're just pooling assets together, and then they're servicing those assets from the payments and distributing them to the investors. It's just securitization. It's not really anything that complex. And when you really understand it, yeah, it'll teach you all of this that they're talking about. It most definitely will. Because that's exactly what secure party is. It's the same thing. The only thing about it is that where is the value being derived at? And it's being contemplated based off of your labor, you being a real living soul, which is what the government does because they use that and go and borrow trillions of dollars from the Federal Reserve. So that's why you're doing that, because you want them to stop doing that in your name. That's one of the things that, you're trying to, really your adversary is this welfare state. Okay, this welfare state is the adversary. And that's what you're really attacking. And that's why I said you got to be watchful, because there are people who have infiltrated this space who, because they're trying to convert the United States to a communist country, and therefore, in those spaces where people are hate the government and are real angry and stuff, those are real good places for them to hide at, because they like to invoke the emotions or fan the flames of anger and emotions of white supremacy and racism, and how the government is not fair, because they got to bring in this new world order, and to bring it in, you got to destabilize everything. So you got to watch and make sure you're not under some sort of influence, and that's why you need to educate. Get a good civic education first, all right, so you can understand what is the proper steps that you should take as a citizen of the country, whether it's a private American citizen, however you want to characterize it. Okay, what are the proper ways? How are you supposed to be conducting yourself? What are your duties? Because with every right, there's a corresponding duty. So you're saying you have a right, okay, that means there's a corresponding duty. All right, that falls right in line with the universal principle of polarity. There are two sides to everything. So if there's a right, there's a duty. Now, what are your duties? These are things that you have to contemplate, when you're doing all of this, if you want to appear to at least, give somebody the impression that you know what you're talking about. But this notion that you can just declare something and all of a sudden the government is corrupt and you're 100% correct, and you can't even understand what these statutes are really talking about, or anything like that, that's concerning. Or you haven't even read the Constitution. A lot of you haven't even read the Constitution. You haven't even read it, and you know you haven't. If anybody want to know who Mr. Brewer is, go and look at the videos. They're on the channel. They see it on the channel. Just go on the channel. Let's go read. He's my partner. An unperfected security interest is subordinate to a lien creditor. UCC 9-31782, between competing perfected interests, priority ordinarily goes to the first to file or perfected. UCC 9322A1, that is first in line, first in time. You know, priority of liens, you know. They had to do that in the public because if there's going to, because you could be doing private business and somebody going and getting a loan from 3 different people while pledging the same collateral. Okay, well, to prevent that from getting into some sort of dispute, they got a public registry called the commercial chamber where you can record a document, okay, from a private agreement so you can establish a priority perfected interest in some sort of collateral. Okay, this is an example of private ordering, but also how private ordering contemplates that it may have to resort to the public courts to get some sort of enforcement. That's why there has to be some sort of compliance with the public in some capacity, because ultimate enforcement is going to come through the public, not you. Unless you have expressly created some sort of remedy for that privately and all the parties have agreed to it, some sort of enforcement or something like that, and it doesn't violate the public policy. You can't write anything that's going to violate the public. What did I say, government? I didn't cut nobody on nothing. Who'd I cut? I ain't cut anybody on anything, real property. A deed is fully effective between grantor and grantee on delivery with no recording, whatever. Recording does not make the deed good. It makes it good against subsequent purchasers on terms set by the state's Recording Act. Race notice or race notice. All right, now this right here just explains what I just got through talking about. First in line, first in time. That is a dispute resolution mechanism that the public has created to resolve private disputes. Right now, we're looking at this play between public and private and how private ordering has to operate within a public framework. That's what I'm trying to describe to you right now. Now, state laws varies. Which of the 3 regimes your state uses determines the outcome, know yours. A private instrument creates the right. A public act makes it good against the world. This is the mechanism students are reaching for when they attempt to bind non-parties by declaration, notice, or affidavit. The mechanism exists. It is not a declaration. It is a filing. It is a designated register. It is a prescribed form within a prescribed time. Note, what the register requires in exchange, you must disclose. Third-party effect is purchased with publicity. An instrument designed to be both binding on strangers and hidden from them is asking for something the system does not sell. In other words, if you're going to have a contract, you're going to have to get publicly put it out there in the public. You can't bind somebody to a contract and haven't given them an opportunity to read it. Makes sense to me. 2.6 worked example, Regulation D. A private placement is the cleanest single illustration in American law of everything in parts 1 and 2 because both halves are visible in one transaction. The parties write a great deal. None of the writing touches the exemption. All right, so when we talk about what we're just asking about Mr. Brewer, and will this help you with what he's teaching? Well, right here is an example of it right here, private placement. Okay, what the parties genuinely order, subscription agreement terms, representations and warranties, indemnification, what no drafting can reach, whether the exemption is available at all. Rule 506B and 506C set conditions. The parties may satisfy them or fail them, not rewrite them. Okay? What the parties genuinely order, transfer restrictions, certificate legends, rights of first refusal, drag along and tag along. What no drafting can reach, resale limits, securities sold under Regulation D are restricted securities, Rule 502D. Right now, we're just seeing how these private transactions are regulated under the Securities and Exchange Administration. Let's go on. Operating a partnership agreement, control economics, distributions, deadlocks, exit. The prohibition on general solicitation in a 506B offering, Conduct governs. A recital that no solicitation occurred does not unring it. Escrow arrangements, closing mechanics, side letters, information rights, accredited investor status, Rule 501A defines it. A person either meets the definition or does not. Okay? This, and I'm not going to read all this, but this right here is just showing you, is attempting to just get into your mind and understanding of how there is a private ecosphere that operates under a public banner. Okay? You got to understand that. The public is what dominates, is because what's good, the goods of the many outweigh the goods of the few. So that makes sense. You know, we are people on this planet living together. Okay, we are by nature social. Okay, so we have to have rules when we interact with each other, and that's what the public is there to regulate, that interaction that we have with each other when we're in the public. When we're in the private, we can write our own rules, but we have to understand what that is. Okay, a lot of the ways that privacy and was looked at 100 to 200 years ago has changed a lot because we have big cities now. We have automobiles, we have roads and highways and things like that. The public has expanded and people have started to engage it on a much more, bigger level than they did in the past. In the past, everybody grew their own food, they built their own houses, they educated their own children. That's what people were doing. When the Constitution was written, people don't do that anymore. You send your children to public school. The government is paying for that. That's why it's called public school. That's a benefit and a privilege. You don't have a right to that. These are the things. Then you have private school. These are things you have to understand. You start understanding them. Okay, we've been taking benefits and privileges from the state, and therefore you're going to be subjected to regulations. Once again, I point toward the Amish. Okay, I think they are a very good example of a group of people that have chosen to live outside of government regulation. But you see what they sacrificed. Modern conveniences. Modern conveniences. It's a convenience. Let's go on. It says the sharpest point in the example, an investor's reputation that she is accredited is evidence, not a fact-creating act. It does not make her accredited. It is nonetheless doing real legal work. Under Rule 506B, the issuer may rely on a reasonable belief that purchasers are accredited, and a well-taken representation supports that belief. Under Rule 506C, where general solicitation is permitted, representations alone are not enough. The issuer must take responsible steps to verify. Okay, so when you're making solicitation, you got to take steps to verify. All right? So the private instrument matters enormously, and it matters within a structure it cannot alter. That is the entire thesis of the handout, visible in a single paragraph of a subscription agreement. Students who work in this area should notice the pattern. The sophisticated practitioner's freedom is very large and very precisely bounded, and knowing exactly where the boundary runs is what the sophistication consists of. That's how you know where your boundary is. If you're sophisticated, you know the demarcation line that separates public from private. And that's what I'm just trying to show you right now. See, nobody has given you some sort of cogent explanation of what exactly separates public from private. That's what you have to understand. And that's what the struggle is for me, because a lot of people have already been indoctrinated with an expectation of what privacy is. And it is an incorrect representation of what it actually is. Trying to overcome that and unwind that. All of us have been indoctrinated to that. I came through the door just like you did. It's amazing to me. I've been in this space 20 years, and to hear the people in the chat talk about things that we've talked about like 2 million times. But they've heard it for the first time, and they think they actually come. The United States is a corporation, as if I haven't heard that 500 trillion times in the last 20 years. But we're trying to undo some of that indoctrination by giving you things that you can substantiate. Aren't you tired of dealing with information you cannot prove? Why not start there? Start with what you can confirm. Start what there is some sort of historical precedence for. Start there. And then if you want to go into the into the conspiracy theories, okay, at least you have a foundation because now you know what the substantive information is. And you can look at what somebody is telling you and say, okay, that may have some substance to it. Or you can look at it and say, that's ridiculous. Ain't no possible way. And you're going to be able to do that. So let's go on. Legitimacy is not jurisdiction. Two separate questions. These are routinely fused, and the fusion is fatal to the argument built on it. Question: is the government legitimate? What kind of question is it? A question of political philosophy and moral theory. It is answered with arguments about consent, natural right, social contract, and the proper ends of authority. If it is a serious question with a serious literature. No court has jurisdiction to answer it, and no court needs to. That's a political question doctrine. Does the tribunal have jurisdiction over this matter and this person? A question of positive law. It is answered by reading a constitution, a statute, and a rule of procedure, and by applying them to facts. It is answered the same way whether or not the government is legitimate. The two questions have no evidentiary overlap. Nothing that would support an answer to the first is admissible on the second. A student who brings philosophical material into a jurisdictional motion has not made a weak argument. He has made a category error, and the motion will be denied without reaching it. And that's what people do. They like to inject their political theories and what they feel like into some of their paperwork that they put into court. Court is about what you can prove. It ain't about your feelings. Court is about what you can prove. And you have to understand what constitutes evidence, not with how you feel about something. Court is not about right and wrong. It's about what you can prove. Real jurisdictional doctrine is rigorous, and it is the better tool. The irony worth teaching jurisdiction is one of the most seriously policed concepts in American law. Courts raise it on their own motion, cannot waive it, and must resolve it before anything else. Federal courts are courts of limited jurisdiction. It is presumed that a cause lies outside that jurisdiction, and the burden of establishing it rests on the party asserting it. The burden of proof is on he who asserts, not he who denies. If you assert something, you're the one that got to prove it, not them. If they assert something, they're the ones that got to prove it, not you. But it applies on both sides. The burden of proof is on he who asserts, not he who denies. Jurisdiction must be established before the merits are reached. There is no hypothetical jurisdiction, okay? Usually you will find in a lot of the motions or when somebody gets indicted, there usually is a jurisdictional element there. A lot of you don't read it or recognize it. Like when the United States, they say this violates interstate commerce, and they have the authority to regulate interstate commerce under Article 1, Section 3 of the Constitution. Article 1, Section 8, Clause 3 of the Constitution, which is the Commerce Clause. So anything related to interstate commerce, the government, or anything that touches interstate or could materially affect interstate commerce, they have a regulatory authority over, which is broad. We haven't even been able to see what the limits of commerce is yet. Subject matter jurisdiction cannot be forfeited or waived and may be raised at any stage. You can raise subject matter jurisdiction at any time. I utilize it all the time, especially if something, I got a default ruling against me. I'll bring up something like this. I'll challenge subject matter jurisdiction. These are real powerful, frequently successful arguments. Removal defects, amounting controversy failures, absence of a federal question, standing defects, and statutory jurisdictional limits win cases every day. Teaching point: the folk version of jurisdiction is not a stronger version of the real doctrine. It is a substitute for it, and it displaces a tool that works with one that does not. This is how you challenge jurisdiction, not the way you've been doing it. The way you're doing it don't work. This works. And it got a long history of working. A student who spends his efforts on the philosophical version never learns the doctrinal version. And the doctrinal version is the one that would have helped him. A lot of you, y'all go into the echo chambers and get some philosophy or some theories that seem like they have some sort of basis. And then you adopt them and you make them a part of your of everything that you have about you. The United States is a corporation. I'm not that person. A person is a straw man. You know, there was a woman who used to bake some bread, right? She bakes them. Some of y'all probably heard me say this, but there was this old lady that used to bake her bread, and when she would knead the dough, she would cut off the ends of the bread before she put it in the pan. And a man asked her, why do you cut off the ends of your bread, when you're getting ready to bake the bread? She said, I don't know, that's just what my mama used to do. So we go to our mama and say, look, your daughter, when she get ready to bake that homemade bread, she cuts off the ends of the bread and puts it in the pan to bake it. Why do you cut off the ends of the bread? She said, I don't know, that's what my mama used to do. And so we go to the grandma and ask her the same question, and then even the great grandma, why is it that when you used to knead the dough, you used to cut off the ends of the dough before you put it in the pan to bake the bread? She said, my pan was too short. A lot of you are just doing things that have been regurgitated, and you don't even know the reason why you're doing it, or don't even know where it originated from. It's just somebody telling you. You can't even substantiate it in any type of case law or nothing like that. It's just somebody telling you something, and it sounded good. And because you had a victim mindset, it seemed like something that you should attach yourself to because you have a me versus them mentality. You're being pulled into a me versus them mentality. Instead of trying to understand how the system operates, we can just, as an excuse, no, it's just corrupt, so I don't need to understand it. That sounds like a cop-out of a person that's not very intelligent. If you ask me, a lazy individual that doesn't, look, I don't even want to take time to read all of this. I don't think I should have to. Well, if you follow sources, you can post your sources. You don't have to claim that you follow sources. It's very evident. It's evident in everything you do. Every time you make a comment, you'll post a source. That's what the attorneys do. They post their sources. You should have learned that when you're in English compositional grammar in high school. Tell you the truth. Ain't no privacy. Don't have nothing to do with that. If you're going to state something, you need to cite your source, or else it's just hearsay. If you can't cite the source, ain't nobody just gonna believe you on something. That's gonna believe you. Somebody just supposed to believe you. Teaching point, the folk version of the okay, let me read this to you again. Teaching point, the folk version of jurisdiction is not a stronger version of the real doctrine. It is a substitute for it, and it displaces a tool that works with one that does not. A student who spends his effort on the philosophical version never learns the doctrinal version, and the doctrinal version is the one that would have helped him. All right? The cases most often misread. Cases most often misread. So what we have? Cheek held that a good faith misunderstood. Okay. Cheek versus United States, volume 498, U.S. Reporter, page 192, published in 1991, is frequently cited as supporting the proposition that sincere disbelief in a legal obligation negates it. It holds close to the opposite, and the distinction it draws is the distinction this entire handout is about. Okay, this right here is, okay, if you truly believe something, then that makes it right. That's something that's been spread around. Cheek held that a good faith misunderstanding of what the law requires may negate the willfulness element of certain tax offenses, however unreasonable the misunderstanding. Volume 498, U.S. Reporter, at pages 201 through 203, settled. Cheek also held that a belief that the tax laws are unconstitutional or invalid does not qualify. Such a belief does not arise from innocent confusion about what the law requires. It reveals full knowledge of the requirement coupled with a decision to contest its validity. And the proper channel for that contest is to comply and litigate, or to litigate without violating. Volume 498, U.S. Reporter, you got to pay under protest if you want to fight the tax laws. And you just claiming that you thought that I didn't have to pay taxes is not an excuse that's going to be acceptable. I hope all the tax protesters be warned, because they're letting you know right there. The case draws exactly the line between not understanding an obligation and understanding it and denying its authority. Only the first is a defense, and only to the willfulness element. Okay, and this is a principle that's an exercise here. Okay, that you are, that you're trying not to understand our obligation. What are your duties? You claiming you have a right. What are your duties? What are your duties? You claim you got a right. What are your duties? What courts do not entertain the legitimacy argument, not because the question is unimportant, but because of what a court is. A court is an organ of the government whose legitimacy is being challenged, constituted by the same instrument and possessing no authority except what the instrument confers. A tribunal cannot coherently adjudicate the validity of its own source of authority. If the challenge succeeded, the tribunal would lack power to enter the judgment sustaining it. Structural. This is a logical feature of adjudication, not a policy of any court. It would be true of a private arbitral tribunal asked to rule that its own arbitration agreement never existed. You asking the government to say the government is illegitimate and the court is an organ of the government, and if it found that that was true, the court wouldn't have the power to issue the order anyway because it's not legitimate, remember? That's why they're not going to entertain that argument. You want to talk about it? Why am I going to talk? No, I'm not going to talk about the vehicle codes because the codes are subject to the Supreme Court. Okay, the Supreme Court has already given rulings on all of this, and you don't understand the code. You're trying to make driving a commercial activity, and that's not what it is. That's not what regulates the activity. Is what I'm trying to tell you. Okay, you're making what is called a off-point argument when you make that argument. That's why I'm not talking about it, because it don't have any relation to it. Okay, so you're making an off-point argument. That's all it is. That's all I'm saying. And you should be able to deduce that if you've actually watched the videos that I've been talking about. That's why I'm not talking about the vehicle codes. That's why I don't talk about it, because it's an off-point argument that you're making. Your rights are enforced through contract. You have inherent rights. You have the right to life, liberty, and the pursuit of happiness. And then you have civil rights, all right, that you've been given. Substantive rights, okay? But a right without enforcement is not a right. So where are you going to get your rights enforced from, okay? If you don't have any enforcement of the right, you got to go to the public to have your rights enforced, dude. So y'all make this argument about rights, but where are you going to get your rights enforced? There is no right without enforcement. There's no right without enforcement. So where are you going to go get your enforcement? Where are you going to get your enforcement? What governs those rights is the agreements entered into and the conduct that you've been engaged in. When you come into the public, your rights are regulated, subject to them when you come into the public. All right? You don't exercise a private right when in a public regulated space. So that's a very big error that you make if you're thinking that. You're thinking that you have some sort of substantive right to do whatever you want to do in a public regulated space. You're a terrorist and you're ignorant, number one. You need to get you need to go and get a basic civic education. You lack that. Okay, your rights come from God. All our rights come from God. And you got the right to do whatever you want to do as long as you don't infringe on the rights of another. And they have something called the public rights doctrine. Okay? All right? So this don't have anything to do with God. All right? You are free to worship in whatever capacity you want to. That has nothing to do with the public. The public is not here to cater to your religious beliefs. That's not what that's not what they're here to do. Okay, so what? And the legislature is subject to Supreme Court decision. The Supreme Court are the interpreters of the law. The legislature writes the law. The court interprets the law. So once again, we seems like we need to get a class on basic civics because people don't understand we have a legislative, executive, and judiciary. The legislature writes the laws, the executive enforces the laws, and the judiciary interprets the law. You do understand what interpretation of law means, which gives you the meaning of things. So they will tell you what something means. Ultimately, they are the ultimate arbiter of what something means, not the codes. Not the codes. And I've already read about 5 cases. Don't worry, I'm gonna give y'all a chance to embarrass yourself. I'm gonna do a call-in show, and I'm gonna let you come in and challenge me, and I'm gonna destroy all of y'all one by one. I'm gonna clown you. Don't worry, I love to do this. Today, I'm just teaching. I can't wait for the opportunity to clown each of you that are in the chat talking right now. I'm gonna utterly humiliate each and every one of you. Trust me, my goal is to utterly destroy you. You don't have to keep typing in, I know who you are. I'm gonna give you that opportunity, all right? Because my goal is to utterly destroy you. That's why you're over here, because right now I'm reaching out and it's reverberating out through the entire community. And it's making you upset because I'm educating people, and I'm gonna continue to do so. And you can't do anything about it. You can't stop it. You can't change it, okay? It's already in effect, all right? I'm here to destroy you. I'm your mortal enemy. And I'm going to do it till there's not a cinder. I'm gonna burn you down to the ground. So you don't have to worry. You're gonna get your opportunity. Just be patient. I'm coming. I'm coming. I'm coming. Just be patient. I'm coming. Just be patient. Let me do this first, and I'm gonna get to you next, okay? I hope you have good insurance, all right? 3.4, why do courts not entertain the legitimacy argument? I just read that, all right? We're gonna go to part 5. How these arguments actually fail, part 4. Not why they are wrong, why mechanically they produce the outcomes they produce. Understanding the mechanism is what allows a student to redirect the effort productively. 4.1, the 4 failure patterns, non-party binding. Mechanism of failure. The instrument purports to affect someone who never agreed to it. Pattern, mandatory rule displacement. The instrument purports to displace a rule that is not a default. Fails on the rule's own terms, often expressly voided by statute. And that's like an administrative process, defaulting people out on contractual terms when they don't have a duty to respond or anything like that. Category error, a philosophical premise is offered where a doctrinal one is required. The tribunal has no procedure for receiving it. You can't come in with your own philosophy into the courtroom. They'll have no way of receiving that. Label over conduct, okay? This is the big one. This is that substance over form. Y'all all like to put y'all words over y'all conduct. The arrangement is renamed rather than restructured. Courts classify what it actually is done. The substance of the arrangement, the actual allocation of control and benefit, not by what the document calls it. Naming is the weakest possible legal act. You think by changing the name of something, it's gonna give it some legal effect, and it doesn't, all right? It's the weakest thing that you can do, and the whole entire body of law doesn't even operate like that. It operates through conduct, okay? That's why if you're gonna put in declarations and all these things, that has to be accompanied with a change in your conduct, meaning you have to set up some sort of private ordering, get you a private trust, understand how to operate that trust, get a private member association or something like that. You're declaring something, but you don't have the infrastructure set up to actually operate what you're saying on paper. That's your problem. Pattern 4 derives emphasis because it is the one that reaches otherwise careful drafters. The disregarded trust line is the standard illustration, with the settler retaining practical control over the property. Okay, I got to pause right here. Okay, let me say this. I'll come back and finish this later tonight. We'll do a part 2. However, this is how I teach class at SBC University. And I do it 2 times a week now. Tonight we have a trust class. And we do this and we go through the case law. and we look at the principles of equity that govern. Okay, this is actual education. It is not actual education that can be utilized in the courts, that you can be competent when you put together a trust, if you're in some sort of litigation concerning a trust, understanding how to draft your instrument, understanding the different purposes of a trust, knowing the importance of citizen shopping, all these things that you learn when you come to SBC University. They're not just words that get thrown out there and then they just dissipate. It's things that you actually learn how to do. A U.S. citizen absolutely can have a private trust. He don't know what he's talking about. You don't know what he's talking about. He said a U.S. citizen can't have a private trust. A U.S. citizen absolutely can have a private trust. Absolutely can have a private trust. That's a bald-faced lie. Yeah. What he's really trying to say is, can you operate a private trust in commerce? See, this is what I'm saying. He doesn't understand form versus substance. The IRS doesn't care if you call it public or private. It can be wholly private. If it does any business with the public, there's going to be a disclosure that is going to be needed because it touched the public. Anything private that touches the public no longer retains that private character. Public and private do not mix. So yes, if you're going to operate and have a private trust and you never need to do business with it or anything like that, it falls within this private ordering infrastructure. However, whether you call yourself a U.S. citizen or not. See, that's what I'm saying. You into labels, and that's what y'all don't understand. This is not how this works. This don't work over labels. This is what I just said right here, label over conduct. That's what you have. You got a label, U.S. citizen. You're putting a label on there. It's not the label U.S. citizen. It is what did the person actually conduct he engage in. Did he engage in U.S. citizen conduct or did he engage in private conduct? Engaging in U.S. citizen conduct is when you come into the public and engage in business or you take a benefit and a privilege. That's U.S. citizen conduct. You just can't just call yourself one thing or the other. It's the conduct that determines what constitutes public and private, not what you call it. Not what you call it. So that's a basic thing that you don't understand. All right, so we got, yeah, so what I wanted to say, I want to invite all of you out this weekend. We're having a webinar. I'm going through a lot of different things. It's at spcuniversity.com. Just hit the store button and you can register it. It's on isolation, securitization, and privatization. You'll see there, it's a webinar, it's $297. It's going to be a 2-day webinar. It's going to be on Saturday from 11 to 3 p.m., as well as Sunday from 1 to 4 p.m. I'm going to be going over a lot of information. I'm basically going to be doing a brain dump because I don't know when I'm going to do another webinar like this. Might be a very, very long time, but I think I owe you at least one more webinar like that. So I'm going to give you a webinar, and I made it a 2-day webinar so I can really, really take the time to go over a lot of different things that y'all have questions about as it relates to any of these processes, what they are for, how do you actually do them, why are you filing a UCC-1, how do you properly discharge or set off an obligation, what is the UCC-3 for, what is it actually for, what is the 11 for, you know, how can I contract with myself, you know, in 2 different capacities on a UCC-1? You know, these are a lot of questions you ain't gonna have answers to, you know, like what he's talking about, who created the birth certificate? Is it their property? See, he's in the labels. He's not into conduct. They don't understand how the law operates. See, that's the biggest problem in that space is they operate off labels. They want to label everything. They don't look to the conduct behind. They looking at what you do with what, right? They don't care what you called it. They don't care where it originated from. What they care about is what is actually being done with it. That's what you ain't catching. That's what you're not catching. You can create a private trust all you want. Keep it out of the public. Keep all the activity associated with it out of the public. And it can remain truly private. But you just calling it private and then bringing it into the public, that's not how, see, that's an administration error. You don't know how to administer it properly to maintain privacy. But anyway, I'm looking at what you're saying. All right, but I'm gonna invite all of you out. Y'all can hit the button. Y'all check that out. I'll put the link in the description. I'm really interested in your comments on this. This is something I'm going to be talking about a lot more on this platform. All right, so like, comment, and subscribe. Hit the notification button if you're going to subscribe, because this is the direction I'm taking everybody. It's going to be a very, very interesting direction. You have no idea how expansive all of these different topics are. When we're talking about trust, when we're talking about contracts and things like that, that's an entire other world that's being opened up to you. All right, so hope you enjoyed this. Like, comment, and subscribe, and I will catch you on the next stream. Peace. I'm out.